Hi, what's going on, everyone? I'm Bob with 1L and Back, and this is the beginning of the civil procedure review part of the Beat the Bar course. So just going to jump right into it. This is an area that nobody really loves to talk about civil procedure. The good news, though, on the bar exam is that you don't have to be a civil procedure expert. You don't have to know how to litigate any of this. You don't have to know how any of this would look in a real motion, right? Anything that you'd file with the court. All we're really doing is we're looking at definitions and elements, right? Just like everything else that we look at, every tort, every crime, there's going to be a list of definitions that we have to memorize as being associated with that thing, right? And then when we see that thing, that term on the exam, as long as we can identify the issue and we see what the bar examiners are doing to us, right? What that bet is, then we can go and just match up the elements. So I'm going to get right into some law here, and we'll dive into it. So first off, the very first distinction that we need to make when we're looking at this big outline the bar examiners give us, we see here we're talking about jurisdiction and venue. So we'll break that kind of right away into two pieces. We're going to set venue aside. We'll deal with venue totally separate. It's a completely separate video, so we'll get there. Right now, all we're going to talk about is this idea of jurisdiction. And jurisdiction, as we know, we have these two different types here. We have this idea of subject matter jurisdiction, and we have this idea of personal jurisdiction, right? So subject matter jurisdiction is ultimately, does the court have the authority to hear the case, right? Is it the right type of case in the right type of court is a way we could think about it. And then the personal jurisdiction we know is about the individual defendant. Does the court have the authority over this particular individual, right? Can the state court in Ohio get jurisdiction over me? Well, right now, no, I'm living in Boston. I don't have any contacts with Ohio, right? So that's kind of the idea. Now, we're going to get into these both separately, and we're just going to take this one step at a time. But the very first thing we want to be aware of, just kind of conceptually, when we're thinking about subject matter jurisdiction, just like it sounds, we're talking about the subject matter of the case, and then we're talking personal jurisdiction. It's going to be specific to the defendant. So let's get into subject matter jurisdiction, right? So we know that there are two different ways, and this is the first big distinction you have to make in your outline. There are two distinct ways that a court can have subject matter jurisdiction. And on the bar exam, we're usually talking about federal courts. We want to be aware that we're reading closely. We know that federal courts are courts of limited jurisdiction, so they are only able to hear certain type of cases, whereas the default, the state courts, general jurisdiction, they can hear pretty much any type of case. So we want to make sure, and this is just, again, this isn't a civil procedure point specifically, this is just to everything. We have to make sure that we're reading closely. Yes, we're going to be dealing primarily with things being in and out of federal court, but you never know. The bar examiners could take a fact pattern that's about federal court and just change federal to state and give you some different answer choices. You're reading through, oh, I've done this question before. I just did this question. Oh, yeah, the answer is C, and it's not. Why? Not even, maybe the answer choices were the exact same. All the bar examiners did was change federal and state, and it gave us a different outcome. So again, we'll get into how we identify some of this, but the most important thing truly is that this is going to be about close reading of the facts. Okay, so we're looking at subject matter jurisdiction then, and we know there are two different ways that the federal court can have subject matter jurisdiction over a case. So first of all, we know that the court can get subject matter jurisdiction over the case in what's called diversity, right? We have two citizens of different states. The easiest, the simplest way to think about this, we're going to have our diagram here with the V in the middle, our plaintiffs and our defendants right on either side. In order for diversity to be satisfied, every single person, every single entity, every single P on the P side has to be of a different citizenship. They must be diverse from every single person, entity, whatever, on the defendant side, right? So everything, there cannot be any overlap where we have a state in common on both sides of the V. And where this is going to be important is not even so much when the case initially starts, right? But we're going to see in some of these bar exam fact patterns that parties are being added. And so we have to make sure that we're watching that the party that's being added is not going to destroy the diversity, because we're going to see that, even in cases where we talk about supplemental jurisdiction and other things down the road, we're always going to come back to this rule, which is that all plaintiffs need to be diverse from all defendants in a diversity case. So it's just that simple. I don't want to get confused and start talking about other issues. Just know that all plaintiffs need to be diverse from all defendants. Now, let's think back to first-year law school. How is citizenship determined? Well, we know it's determined by where you are domiciled. So where that plaintiff is going to be domiciled. What does domiciled mean? So we're talking about an individual first. We're going to get to corporations. If we're talking about an individual, that means they are domiciled where they are living, where they're residing, with an intent to remain indefinitely. So like I said, you guys know from some of the other things that I've done, I'm originally from Cleveland. I'm a huge Browns fan, well, they're not the Indians anymore, huge Guardians fan, right? Buckeyes, all those teams. I love Ohio. I love Cleveland. I have no contacts there, though, other than watching the Browns lose on Sunday, right? The idea is that a court in Ohio, just because I was born there, just because I maybe one day have an intent to go back there, not really, but maybe, that is not going to be sufficient just because I have some connections with the state if I don't actually have ongoing relationships with that state, right? The idea is that I'm not going to be domiciled in that state, even if I've lived there previously. So don't confuse this whole thing with the minimum contacts piece. We just want to understand that domiciled is where you are residing with an intent to remain permanently. Sometimes the facts will give us something that this person intends to move to this other place, but unless they've started the moving process, they are domiciled where they're living. All right, and so if that is how an individual's citizenship is going to be determined, right, where they're domiciled, where they're living with an intent to remain indefinitely, for the corporation, we know they are a citizen of two places, right, usually, right, potentially is what we should say. Why do we say that? Because they are the citizen of the state where they're incorporated, and they are also a citizen of the state where they have their principal place of business. Now, keep in mind, this is not necessarily two different places. So my company, One Island Back, a good example of that, right? So I'm incorporated here in Massachusetts, and our principal place of business happens to be here in Boston too. So I don't have a headquarters in another state, right? But you hear a lot of times, and we have fact patterns, right, where you'll have companies that are headquartered in, let's say, Delaware, right? A state, great tax situation there, but their principal place of business is maybe in like New York or something. And so the idea is that they have their headquarters in this other state. They're incorporated in, let's say, state A, their headquarters is in state B. We know for the corporation, they're citizens of both of those states. Now, why is this important, right? Why is this something we want to pay close attention to? Because we know that in diversity, if a party is being added, like, that party can't destroy diversity, and we have to pay attention if we are adding a corporation, let's say, that happens to be incorporated in the same state as the plaintiff. So in this hypo, we'd be adding a corporation as a defendant, and our plaintiff is from that same state. Let's say even though that corporation does their principal place of business, they do all their operations, everything in the other state, if they're incorporated in that same state as the plaintiff, in this little mini hypo, that's going to destroy diversity. That's no good. So what do we need to mainly take away and remember here is that in diversity, all the plaintiffs need to be diverse from all defendants. The plaintiff's citizenship, how we know what little state to associate them with, is, well, how do we know? Really, they're going to give it to us, and what they're going to tell us is where that person is living with an intent to remain indefinitely. That's for the individual. For the corporation, we just have to know where they're incorporated and if they have their principal place of business in another state. And then we just check to make sure that there's no overlap, that the states are different, and we just need to make sure that the amount in controversy is satisfied, right? Remember, the amount in controversy, $75,000, and the idea with that amount in controversy is essentially that's just what the plaintiff is. We can think of it almost like what they're eligible for, what they can get, what their claim legally would support. So the idea is there's no real check, if you want to think about it like that, on how, if the plaintiff says their claim is worth $80,000 and the court subjectively disagrees with that, that's not going to be enough to say that the amount in controversy is not met, right? The idea is the amount in controversy, if the plaintiff is pleading more than $75,000, the only way the amount in controversy wouldn't be met is if the court determines to a legal certainty that the amount in controversy would not be met. And so what do we want to look at here? Right, this is if like statutorily, right, the way the statute is written, recovery under this particular theory, whatever the plaintiff is suing for, recovery might be capped at say like 30K. So, and they're not bringing any other claims. And so in that case, the court would know to a legal certainty that the relief, the damages could not exceed $75,000. In that case, and that hypo is out there, you will see that. In that case, we just have to be aware of what's the buzzword, what's the definition that we're looking for. The court determines to a legal certainty that the amount in controversy could not be satisfied. So that's the idea there. Okay, the other weird thing we should say about diversity is that if we have citizens of foreign countries, one citizen is a citizen of a state and the other citizen is a citizen of a foreign country, diversity is going to be satisfied. If we have citizens that are if we have individuals that are both citizens of foreign countries, then we're not going to have diversity because we don't have any state that is going to be associated with those people, right? They're going to have to bring that action somewhere else, right? Wherever they are a citizen of, in that case. Not a hypo that we want to be too worried about, but just something that's out there. And that's it for diversity, guys. I mean, really, it's a lot of close reading. You'll see when we go through and do some examples, right? But the idea is this is all in the facts. Everything you need to know for a diversity case, a diversity hypo, is right there. It's just close reading. All plaintiffs diverse from all defendants. Amount in controversy needs to be satisfied. So then beyond the diversity side of subject matter jurisdiction, right? We're still talking subject matter jurisdiction. We have this other idea of federal question, okay? And federal question, how does this break down elementally for the bar, right? Federal question is going to be comprised of the well-pleaded complaint rule. This is something we need to be aware of. We need to be aware of the idea of a private right of action, although that's not tested nearly as often. And then we need to be aware of this idea called the forum defendant rule, and we'll see how this plays in. And then we're also going to look at a couple of weird instances that are just guaranteed to be in federal court, right? Where the federal court automatically has subject matter jurisdiction, right? So let's start with this idea of the well-pleaded complaint rule, because this is the most commonly tested aspect of federal question jurisdiction. So we know that even if two parties are not diverse, right? There's a state citizenship in common, that a federal court could still hear a case between those parties if there is some issue of federal law that's at stake, some issue of federal law that the court wants to hear and decide. So the idea, though, is that with this well-pleaded complaint rule, the plaintiff, in their initial complaint, right? So on the face of their complaint, and we talk about what needs to go into a complaint in a completely separate section, but the idea is in that complaint, one of the very first things they have to state is their grounds for jurisdiction. And so they're going to have to say that their claim arises under this federal law. And so here we get this idea of arising under. That is another buzzword we want to be on the lookout for. But again, where this gets tested is that if the defendant is the one that's going to be asserting a defense under federal law, right? Let's say the plaintiff alleges some violation of some state law and the defendant says, well, my defense is that there's actually this federal law that supersedes that. The idea is that is not going to satisfy federal question. That is not going to be okay in terms of allowing the court to have jurisdiction of it. What are we talking about? Because what I just gave you there, the defendant was the one that was raising the claim, right? So that's something that we need to be on the lookout for, just also going forward. Right, and so now when the defendant is the one that's asserting the claim, and that is not going to satisfy our definition for what it means to be the well-pleaded complaint. Remember, the plaintiff has to be the one that's raising the issue of federal law. And this is typically going to be really easy to see on the bar exam as long as we're reading carefully, right? Because the bar examiners are going to have to tell you why the plaintiff is suing. And it's usually, if we're talking about federal question, going to say the Federal Automobile Safety Act, right? Or the Federal, Internet Service Provider Registry, or some type of federal law, federal rule, federal code that is allegedly being violated. That has to be brought up by the plaintiff. The other idea, and this is not tested nearly as common, although I want you to understand it because it's a tricky one if you do miss it. It's just this idea that the law has to give the citizen that private right of action, it's called, and the law has to give the citizen the ability to sue for damages under that law. So sometimes the laws are written in such a way that citizens aren't going to be able to sue one another in violation of it. And so we just have to be aware that the claim arises under federal law. It arises under a law that gives the plaintiff that private right of action. So those are just some buzzwords. We don't need to worry about those nearly as much as that first part. But again, just understand that it has to be the plaintiff bringing the issue of federal law, and that federal law has to essentially be one that allows a plaintiff to sue under it. So that is the idea really with federal question. Now, we know there are a couple of cases as well that are going to be automatically federal question, right? So where does the federal court automatically have jurisdiction? So what are some of those? Well, my favorite, right? Maritime. You guys know I'm a big Arrested Development fan, so we love the maritime law connection there, but we also have patent and trademark. Those are going to be tested more often. If you see anything having to do with a patent, with a trademark, the facts may not say federal patent law, federal trademark law. They're expecting you to know that the federal court automatically has jurisdiction in those areas. Admiralty, it mixes in with the maritime as well. Also, I do want to point out they're really kind of just one-off questions, but certain claims under the Violence Against Women Act is sometimes tested, as well as what's tested even more often than that, state law workers' comp claims. So if you are an employee of the state and there's a workers' comp claim essentially against the state under the state plan, that is something that's going to be heard in federal court, right? And the idea is just that, it's more fair, right? And so just be on the lookout. If we see a state law workers' comp claim where the state is mixed up in it, that's something you just want to be aware of. There's at least one or two, official NCBE questions floating out there where that is the correct answer. And so because I've gotten those wrong and now I know what the answer is, I pass it on to you. And so that is it for our subject matter jurisdiction, right, in terms of the two types. How is this typically going to be tested beyond what we've talked about so far, just definitionally? The other way this is going to be tested, the most common way, in fact, this is going to be tested, is the bar examiners will make it look like it's a question about diversity jurisdiction. So they'll make it look like the analysis that they want you to perform is about diversity. And they'll slip in something like what I talked about with the corporation, where maybe the corporation happens to be a citizen by virtue of being incorporated there, where they have their principal place of business on the other side of the country. But maybe there's this kind of, connection where essentially because you know that the citizenship of a corporation is determined by these two things, you know that actually, hey, this corporation happens to be a citizen of the same state that the plaintiff is suing. And so you know that there's not diversity. And you think the analysis is done, and you jump down and you see answer choice A that's sitting there and says dismissed for lack of diversity. You pick it and you're wrong. Now, why might you be wrong in that case? Well, you're wrong because if we keep reading in the facts, we see that even though the diversity element wasn't satisfied, in fact, the federal question was satisfied because the plaintiff was suing under this other claim. The plaintiff was suing under a federal, safety statute. It's federal food labeling, whatever. There's all kinds of weird ones that they come up with. But the idea is that we have to be sure to perform both parts of this analysis. If we know the question, so we know it's going to be civil procedure, right? That's easy to identify. And knowing that it's a question about jurisdiction, and particularly subject matter jurisdiction, is going to be pretty easy to identify. But then we have to look and see, okay, it looks like they're telling me this question is about diversity. The answer may be about diversity, and we know those elements cold, but we also know that sometimes they slip in stuff about a federal question. We have to make sure, close reading of the facts, all those things that we're talking about, right? And this is the whole idea with the going slowly through the facts and reading each word carefully, understanding what each sentence is trying to say. We don't have to go back and forth from the facts to the answers, from the facts to the answers, right? So that's the idea. We just understand what's going on in the question and we pick the definitional answer. Pretty straightforward. All right, so getting into this next area, this is personal jurisdiction, and completely separate from subject matter jurisdiction in this way. When we talk about subject matter jurisdiction, we know we're talking about the type of case. Personal jurisdiction, we're talking about the individual defendant, right? Can the court reach out and get jurisdiction over that defendant? And so, again, there are really two main areas we need to break this into, right? So there's two ways we need to think about this. There's this idea of the defendant being physically present in the state. The traditional bases, we'll talk about how those are tested. That's easy, as long as we memorize some quick definitions. And then we also have this other analysis under a state long-arm statute, minimum contacts, purposeful availment, all that good stuff. We will get to that, see how it's not really that hard. But it's something that's going to require practice, again, because a lot of that stuff is really an example of an essay. And we're going to see that on the bar exam on MBE, you can't write an essay, right? You can't argue, you can't sit there and reason through what the correct answer is. And so we'll come back to that. But let's get into this idea of personal jurisdiction, and specifically we're going to talk about the traditional bases. Okay, so we probably remember from beginning of law school, there's this idea of personal jurisdiction where the defendant is physically present in the state when they're served. And so kind of where do we want to start here? Well, exactly. If the defendant is domiciled in a state, the defendant's living there, so I'm living here in Massachusetts, I'm going to be subject to personal jurisdiction in Massachusetts, even if the process server doesn't come up and find me. We're going to talk about service of process and proper service later. But the point is that I'm a citizen of that state. I'm domiciled here. I'm subject to personal jurisdiction here pretty much no matter what, right? There's no way that I'm going to say that Massachusetts doesn't have jurisdiction over me as long as I'm domiciled here. So that's simple, right? Domicile, easy. The next one that we want to talk about is physical presence. All right, this is what sometimes gets referred to as tag jurisdiction. This is the idea that you're physically present in the state and the process server comes up and hands you service. They get you to, you say your name, hey, I'm Bob White, but you've been served. So the idea here is that physical presence is enough for this base for personal jurisdiction. Now, there's a couple things I want to say here. First of all, we know there's exceptions. We know that if you're brought into the state by force, by fraud, right, you got to come to this state because, somebody calls saying that, oh, your loved one's in the hospital, you got to get here right away. and the person, drives to the hospital and then they get hit with the service. The idea is that is not going to be valid for purposes of personal jurisdiction, right? We don't need to worry about that, although we do sometimes see that. It's just the idea is as long as we're reading closely, the bar examiners are going to make it obvious if they're testing you on this piece, and it's going to be somebody who is being brought into the state via force or fraud. The other thing that we want to be on the lookout for is if you are only in the state because you are answering another summons. You are in the state because you have to go litigate in the state for some other reason, right? So let's say I'm wrapped up in litigation in, I don't know, Connecticut, and I have to keep going down to Connecticut, and somebody who lives in Connecticut who wants to sue me in Connecticut knows that I'm going to be there, but I'm only there because I'm dealing with this other court procedure, and they try to hit me with service. That's not going to be valid. But let's say that I'm just passing through the state and I stop for gas, and it just so happens that the process server sees me and he, hits me with the service of process. That's going to be enough for this traditional base for personal jurisdiction. Now, that's not the same thing as saying that's going to be sufficient to make me actually litigate in that state, because you'll see when we do our venue analysis and transferring venue and all that other good stuff that we get into, I may not have to actually litigate there, right? But in terms of personal jurisdiction, that is a valid application of that traditional base for jurisdiction, right? The court has personal jurisdiction over you if you're physically present in the state and you get served with process. Now, there's this other weird hypo about if you're like managing an estate and you're not in that capacity and you're vacationing somewhere else. We'll talk about that hypo because it ties in with some other stuff. But again, the idea is that physical presence, unless we're talking about force or fraud or only being there to attend to another court procedure, physical presence is going to be enough. The last two, easy. We have consent, right? You can always consent to litigate in that state. And then we have waiver. Now, waiver is going to be important. Motions is a completely separate portion of this course, totally different set of rules. But there's this one little piece of, it does overlap, and it's that if the defendant does not challenge personal jurisdiction in their initial answer, or if they have a pre-answer motion, because sometimes you'll have a pre-answer motion, which is attacking the sufficiency of the complaint. Don't worry about that now, but just understand that it has to be the first thing that the defendant files. If they're going to challenge personal jurisdiction, they have to challenge it at that time. They have to say at that time, Judge, this court does not have personal jurisdiction over me, and here's why. They have to say that in the initial answer or in the pre-answer motion. If they don't, then that defense is going to be waived. Remember, we know that either party, you can amend the pleadings as a matter of right within 21 days. So just be on the lookout for it. And we're going to talk about those rules in a completely separate chapter. So if you're watching this, I'm sure for the first time before you've gotten to that, don't worry, we're going to cover all of it. Here's the point. We will sometimes see a defendant file their initial answer and they didn't challenge personal jurisdiction. And then a week later, they want to amend their complaint so that they do. The question is, have they already waived it because they didn't answer it, they didn't raise it in the initial answer? And no, the answer is no, they can amend within that 21 days. They could amend to challenge the personal jurisdiction. Now, after that 21-day period, there's amendment by leave of court, and that's a whole separate thing that we'll get into. And that later example, where it's more complicated, is not really going to be tested. What is potentially going to be tested, what I have seen tested because I've gotten it wrong, is where we have the plaintiff suing the defendant. The defendant answers, does not include the defense for personal jurisdiction. Then they come back later and they realize, oh, I wanted to do that, and they try to amend their complaint. If we're within that 21-day window, have they waived it? Have they lost their opportunity to assert personal jurisdiction? The answer is no, right? That is amendment as a matter of right, and we're going to see that when we talk about the pleadings. So stay tuned for that. But just understand that there is some application here when we're talking about the traditional bases and waiver. So, okay, real quick, back to the top. What are our 4 traditional bases? This is easy. This is domicile, right? This is physical presence, the tag jurisdiction, consent. I can always consent to litigate in the state. And then waiver, right? If they don't raise it in the initial answer or in the pre-answer motion, right? The final version of either of those that the court gets. So that is the traditional basis. Now, what is common in each of those, at least to some degree or another, is this idea of the defendant being physically present in the state. We also have cases where the defendant is not physically present in the state, don't live there. I talked earlier about, I'm originally from Ohio, but I don't live there now. What if the court in Ohio wants to get jurisdiction over me? Well, every state has a state long-arm statute. Typically, this is going to be written on the bar exam like the state long-arm statute extends to the limits allowed by the Constitution or the limits allowable under due process. And the idea is that's the same analysis. This whole thing we're talking about is due process and really fairness, right? Is it fair for a court in another state to be able to reach out and grab, let's just say me, when I'm, 1,500, 3,000 miles away, right? Can the court actually go out and do that? Can they make me litigate in that state? We're going to see there are cases where they can, but certain criteria have to be met. So now we're going to get into some big time buzzwords, and this is something clearly for the essay you're going to write a lot about. There is almost 3/4 of the time there's going to be one of the essays dealing with civil procedure and minimum contacts and purposeful availment and all of that good stuff. On the bar exam, I'm going to tell you how we handle this, MBE, different from the essay here. But let's first just hash out kind of our general buzzwords and what we're talking about. So we have this idea of a state long-arm statute, and we know that the state long-arm statute is going to essentially go out to the limits of the Constitution, which invokes this idea of due process. So what is the next level of our analysis? This is where we get into minimum contacts. Our minimum contacts there, do minimum contacts exist between the state and the defendant the state is trying to get jurisdiction over? Are minimum contacts there such that it does not violate, and this is the big buzzword, right, traditional notions of fair play and substantial justice? Lately, I think they've kind of dropped the substantial part of it, and the way they teach it now is traditional notions of fair play and justice. Either way, that phrase, which we remember is from International Shoe, right, the one Civ Pro case you maybe remember reading, that phrase, traditional notions of fair play and justice, is equivalent to due process. So is it going to violate our understanding, our traditional understanding of due process rights by making this defendant litigate in the state? And we have kind of a test that we use. This isn't quite strictly elemental, but you do want to have both of these things in mind, right? The first is the idea of purposeful availment, and the second is the idea of the defendant knowing or should have known that they would be expected, required, potentially might have to litigate in this state. So let's talk about the first one, right? Purposeful availment. Am I taking advantage of the benefits, the laws, and the protections of the forum state? Am I driving on the state highway, right? The state toll road? Am I holding a trade show in the state where I am taking advantage, I'm invoking, I'm expecting protection from not only the fire and the police department, but also consumer protection laws, right? So whatever business I'm doing there, I'm not getting ripped off, right? If potentially, God forbid, somebody tries to do something like that, I have protections from the state. So the idea is if I have that relationship with the state, and it could be either as an individual or a corporation, the idea of purposeful availment is just that I am utilizing, right? I was going to say availing myself of, but we don't want to use the word in the definition. But the idea is that we want to see some action on the part of the of the defendant, tying them to the state if we're going to say that they've purposefully availed themselves. Now, there's another kind of level of this analysis when we talk about, particularly with a corporation. We're looking at whether or not the contacts between the corporation and the state are systematic and continuous. Now, if you're writing your essay, this is how you want to do it. You want to work through and be hitting all these things, right? So all these buzzwords are going to get you points on the essay. In the multiple choice, the way this is really going to look is this is going to have to just be done with practice, because typically they're going to make it really obvious. Either this person or this company is doing business regularly in the state, and there's no doubt that their connections with the state are systematic and continuous and that they've purposefully availed themselves. Or the person has never been to the state, has never done any business there, and there's no reason at all why you would expect the court to have jurisdiction over this person. Every so often, they give you one that's in the middle. Every so often, they give us one that, well, it kind of could go either way. Maybe they've done a little bit of business there. Maybe they had one account there. What do we do in that situation? Well, in real life, and in the essay part of the bar exam, we apply our lawyer thinking and we analyze what the minimum contacts are, and we analyze purposeful availment, and we do all of that stuff. That is not what we do on MBE. On MBE, when we are confronted with that situation, we look down to the answer choices. And there will only be one answer choice talking about minimum contacts, talking about purposeful availment. There's only going to be one answer that is going to be basing its conclusion on the sufficiency or lack thereof of the minimum contacts that that the defendant has with the state. So the other answer choices are going to be talking about things like supplemental jurisdiction, like waiver, like consent, right? Things that we know aren't what the question is really talking about. And that's how you know, right? So by approach, if we recognize that the bar examiners are using that technique of ambiguity, where they've given us one that looks like it really should be an essay question, when we know based on the facts and the call of the question that we think that really this is something that we could argue, it's ambiguous, we're going to look down into the answer choices and we're going to find the only answer choice that talks about the elements that we know we're being asked about. So this seems like it could be an essay about minimum contacts. What is the only answer choice that is talking about the minimum contacts or lack thereof? And here is the most important point about this. You probably will, I know I definitely will, disagree with the conclusion that they make you come to, right? So they will set it up in such a way that, again, it's a little ambiguous, but probably not minimum contacts. But the only answer choice talking about minimum contacts is going to say, yeah, there probably will be jurisdiction there. Now, if you're thinking about this like a lawyer and you're doing your lawyerly analysis, and you haven't gone through and done the approach this way, you might dismiss that answer, the correct answer, out of hand because you don't like the conclusion. And you're thinking, well, I got to get to the conclusion. That's not the right approach for MBE. MBE, it's not about the conclusion they make you come to. And that is huge. That is huge. That is the difference for somebody watching this between passing and failing. Do not get tied down in the conclusions they make you come to. There is only going to be one answer choice that is talking about the correct elements. And if you can see that, and then you start to recognize, oh gosh, wow, these other answer choices are not talking about the elements that have to do with minimum contacts. They're talking about other stuff. I get it now. I see what they're doing to me. I have confidence. I know I can beat the bar. This is not really that bad. Okay, so that's how we handle this. Boom, see, I'm getting excited. We're rocking, we're rolling. Let's get into the next part.